नमस्कार। R.K. त्यागी, गाजियाबाद NCR दिल्ली। ओम सच्ची जनवाणी चैनल पर आपका स्वागत है। प्लीज़ शेयर दी वीडियो, लाइक एंड कमेंट। वीडियो शेयर करने से सभी रिटायरीज साथियों तक जाती है, मोबिलाइज मोटिवेट होते हैं, पब्लिक एट लार्ज तक जाती है, ऑल सेक्शंस ऑफ सोसाइटी, ऑल सेक्शंस ऑफ पॉलिटिकल पार्टीज तक जाती है और कहीं ना कहीं गवर्नमेंट तक भी जाती है अगर आप वीडियो शेयर करें अधिकाधिक। और चैनल को सब्सक्राइब अवश्य करें, इससे हमारी बड़ी मदद होती है, चैनल का विस्तार होता है और आपका कोई खर्चा नहीं आता और 1-2 सेकंड लगता है। आइए वीडियो शुरू करते हैं। ये वेणुगोपाल जी का मैसेज है और वेणुगोपाल जी ने भी भेजा और मुझे मूर्ति जी, श्रीनिवासन मूर्ति देवलापल्ली जी ने इसको आगे फॉरवर्ड करा है। ये कहते हैं, गुड मॉर्निंग, दिस इज द ओनली मैटर टू बी हाईलाइटेड। ए पोर्शन ऑफ द बेसिक पे वाज कार्व्ड आउट विद रिट्रोस्पेक्ट इफेक्ट फ्रॉम 1st November 12 through the joint note dated 25 May 15 as special allowance. Though joint note dated 11th November 20, a similar exercise was done with retrospect effect from 1st November 2017. The pension regulations are statutory and provides for payment of dearness allowance on full basic pay and other components of salary. The ruling of 2 judges bench in civil appeal number 5525 of 2012 with Bank of Baroda and another versus G. Plani and other makes it loud and clear that the pension regulations are statutory and the joint note cannot supplant any of the provisions of the regulations by laying down as below. Quote 15 point है. First we come to rigor of the regulations. The regulations have statutory force having been framed in exercise of the powers under section 19(2)(f) of the Act 1970 and are binding. They could not have been supplanted by any executive fate or order or joint note which has no statutory basis. The joint note of the officers also had no statutory force behind it and could not have obliterated any of the provisions of Act of 1970 or the existing regulation. Thus, joint note could not have taken away the right that were available under the pension regulations of 1995 to the officers. The joint note has no statutory basis and fails to override the pension regulations. 23rd, pension is a right and is not a bounty and cannot be dealt with arbitrarily. In the instant cases, the existing provisions could not have been amended with the retrospective effect, taking away accrued rights on the basis of joint note which had no statutory backing. ये संबंध स्पेशल अलाउंस के संबंध में है सारा और ये मैंने पहले भी एक बार बताया था, डिटेल्स बताई थी आपको और वो कुछ ज़्यादा लंबी डिटेल थी, अब थोड़ा शॉर्ट में है ये। The ruling is a specific accrued right cannot be taken away with retrospective effect on the basis of a joint note which has no statutory backing. The joint note is signed between Indian Bank Association and Union of Employees and Association of Officers and it cannot trample upon the pension regulations which is a dispensation of the legislature. 28. Thus, the joint note agreement could not have been in derogation of the existing statutory regulations, and regulations 2SC could not have been given retrospective effect. It is also apparent from the decision of this court in P. Sadgopan versus Food Corporation of India 1997 for SSC 301 that executive instructions cannot be issued in derogation of the statutory regulations. The settled position of law is that no government order, notification or circular can be a substitute of the statutory rule framed with the authority of law in Dr. Rajinder Singh versus State of Punjab and others 2001 5 SCC 482. This court had reiterated that the settled position of the law is that no government order, notification or circular can be substituted of the statutory rules framed with the authority of law in K. Kupuswamy and N.R. versus State of Tamil Nadu 1998 SCC 469. This court has observed that statutory rules cannot be overridden by executive orders or executive practices. Merely because the government had taken a decision to amend the rules does not mean that the rules stood obliterated till the rule is amended. The rule applies. Next 29 para. Thus, in our opinion, the regulations which were in force till 2003 would apply with the full force, and as a matter of fact, the announcement made in it by addition of explanation C in regulations 2S did not have the effect of amending the regulations relating to pension as contained in regulation 38. Read with regulations 2D and 35 of the regulations of 1995. Even otherwise, if it had the effect of amending the pay and perks average emoluments as specified in regulations 2D, it could not have operated retrospectively and taken away accrued rights. Otherwise also it would have been arbitrary exercises of power. Besides, there was no binding statutory force of the so-called joint note of the officers association as admittedly to officers association. Even the provisions of Industrial Disputes Act were not applicable, and joint note had no statutory support, and it was not open to forego the benefits available under the regulations to those officers who have retired from 1st April 1998 till December 1999 and thereafter, and to deprive them of the benefits of the regulations. Thus, by the joint note that has been relied upon, no estoppel said to have been created. There is no estoppel as against the enforcement of the statutory provisions. The joint note had no force of law and could not have been against the spirit of the statutory regulation and the basic service condition as envisaged under the regulations framed under the Act of 1970. They could not have been tinkered with in our arbitrary manner, within an arbitrary manner, as has been laid down by this court in Central Inland Water Transport Corporation Limited and ANR versus Brozo Nath Ganguly and NR and Delhi Transport Corporation versus DTC Mazdoor Congress 1991 Supplement 1 SCC 600। अच्छा पैरा नंबर 30 पढ़ते हैं। पैरा नंबर 30 में कहते हैं रिलायंस हैज बीन प्लेस्ड on the decision of this court by learned counsel appearing for the bank's own Manoj Bhai N. Saha and others versus Union of India and others 2015 4 SCC 482 where the position was converse revision of pay was granted with retrospective effect to the eligible employees. Instant cases are not the cases of the revision of benefit being given with retrospective effect but taking away of a right that had accrued with retrospective effect. Thus the decision in the aforesaid case has no application. ये थोड़ा लंबा हो रहा है लेकिन अच्छे प्रोविजन वो उपबंध और व्याख्या की है स्पेशल अलाउंस के संबंध में, तो ये आप एक बार देख जरूर लें। Thus the decision in the aforesaid case has no application। 33 पैरा है। The only purpose of addition of explanation C to regulations to S was to take away this actual computation of the pension on the basis of the salary which was drawn in the preceding 10 months. Thus we have no hesitation to strike it down being authority arbitrary and repugnant to other provisions regulations namely 2D 38(1), 2 and 35. The explanation C to regulation 2S is hereby struck down as it could not have been enacted retrospectively to take away accrued rights even otherwise also it is held to be arbitrary and irrational, more so in view of the fact that only by way of temporary measures that discrimination was created and the explanation was deleted with effect from 1st May 2005. The pension regulations are put in place in exercise of powers conferred by Section 19 of the Banking Companies Acquisition and Transfer of Undertaking Act 1970. Section 19(1) and 19(4) prohibits making of regulations and are inconsistent with the act of any scheme made thereunder, which includes the pension scheme, by laying down as below. 19th पैरा है। ये सब रिट पेटिशन जो है उसका है, उसके हिस्से हैं जो कंटेम्प्ट पेटिशन में सुप्रीम कोर्ट में इन्होंने लगा रखा है पंजाब नेशनल बैंक ने। पावर टू मेक रेगुलेशन 1 द बोर्ड ऑफ डायरेक्टर्स ऑफ कोरस्पॉन्डिंग न्यू बैंक में आफ्टर कंसल्टेशन विद द रिजर्व बैंक एंड विद द previous sanctions of the central government by notification in the official gazette make regulations not inconsistent with the provisions of this act or any scheme made thereunder to provide for all matters for which provisions is expedient for the purpose of giving effect to the provisions of this act. Number 4, every regulation shall, as soon as may be after it is made under this act by the board of directors of the corresponding new bank, be forwarded to the central government, and the government shall cause a copy of the same to be laid before each House of Parliament while it is in session for a total period of 30 days, which may be comprised in one session or in 2 or more successive sessions, and if before the expiry of the session, immediately following the session or the successive sessions of the aforesaid, both houses agree in making any modification in the regulation, or both houses agree that the regulations should not be made, the regulations shall thereafter have effect only if such modification modified from form or be of on effect as the case may be. So however that any such modification or annulment shall be without prejudice to the validity of anything previously down under that regulations inserted by Act 1 of 1984, Section 69, with effect from 15th February 1984. The joint notes 25 May 15 and 11 November 20, taking away the accrued statutory rights from 1st November 12 and from 1st November 17 respectively, are inconsistent with the pension scheme and are void in law. The provisions of the joint note so far as relating to the carving out of portion of the basic pay and treating it as a special allowance are void in law in terms of sections 19(1) and 19(4) the act. तो ये था साथियों स्पेशल अलाउंस का मैटर। CN वेणुगोपाल ने ये भेजा था और मूर्ति जी ने भी भेजा था। तो ये उसके हिस्से हैं रिट पेटिशन के। धन्यवाद। भारत माता की जय। वंदे मातरम।